It is 4:45 on a Saturday afternoon, March 25, 1911, and on the 8th floor of the Ash Building at 23 Washington Place in Lower Manhattan, the workday is almost over. The pay envelopes are on the table. The women are reaching for their coats. They are mostly young, mostly immigrants, mostly between the ages of 16 and 23, and they have been bent over sewing machines since 7:30 in the morning, cutting and stitching shirtwaists, the light cotton blouses that fashionable American women wore that season, and they are tired in the particular way that only repetitive physical labor produces, a tiredness that lives in the shoulders and the back of the hands. The foreman has already begun turning off some of the overhead lights. Someone smells smoke. It is not immediately alarming. Then it is everything. The fire moves fast on the 8th floor, where thousands of pounds of cotton scraps fill the bins beneath the cutting tables, where tissue paper patterns hang from lines above the machines like pale flags, where the oil in the sewing machines has soaked into the wood floors over years of daily use. Within minutes, the room is chaos. The workers run for the doors. The Green Street door on the north side of the floor opens. The Washington Place door on the east side does not. 146 people will die before the afternoon is over. In the fire, on the fire escape that tears away from the building under the weight of too many bodies, on the pavement 9 stories below. The number will be confirmed by morning. The question of who was responsible will take much longer, and the answer the legal system eventually produces will be one of the most contested and consequential verdicts in American labor history. To understand why, you have to go back to the morning after, to the moment when a second failure began, quieter than the first, and in some ways more durable. On the morning of March 26, 1911, Fire Marshal William Beers arrived at 23 Washington Place with a team of investigators and began the work of reading what the fire had left behind. The building was still standing. The Ash Building was a 10-story loft structure completed in 1901, built to the specifications of New York City's existing fire code, which at the time did not require sprinkler systems in buildings of its class. The top 3 floors had been occupied by the Triangle Waste Company. The 9th and 10th floors were largely intact. The owners and several managers had escaped via the roof to the building next door. The 8th floor was where the fire had started and where the physical evidence was densest. Beers and his team moved through the space methodically, documenting what they found. The Green Street stairwell door on the north side of the 8th floor had been open at the time of the fire. Workers had escaped through it, and the door showed no signs of having been locked or blocked. The Washington Place stairwell door on the east side was a different matter. It was locked. The lock was a standard bolt mechanism, operable from the inside only with a key, and no key had been found in the door at the time of the fire. The fire escape on the Washington Place side of the building had collapsed under the weight of workers attempting to descend. Beers documented all of this in his official inspection report filed the same day. The physical record was clear. The locked door was not a theory. It was a fact established within 24 hours of the fire by a city official in a formal document. What it meant under the law was a question that would take 9 months and a murder trial to answer, and still not resolve cleanly. The survivors were interviewed in the days that followed, many of them still in shock, some recovering from burns or injuries sustained in the escape. Their accounts were collected by investigators from the Manhattan District Attorney's Office, building toward a grand jury proceeding. Among the survivors was Kate Alterman, a 20-year-old worker from the 8th floor who had escaped through the Green Street door. Her account of what she witnessed in the minutes before her escape would become the most detailed and most contested testimony of the entire legal proceeding that followed. Alterman told investigators that she had seen other workers attempt to open the Washington Place door and find it locked. She described witnessing a man she identified as Bernstein, a bookkeeper employed by Triangle, try the door and fail to open it. She described the smoke, the heat, the sound of the fire consuming the fabric scraps. She described the moment she turned and ran for the Green Street exit. Her account was specific, sequential, and consistent with the physical evidence Beers had documented. It was also, as the defense would later argue, almost too consistent, a detail that would become the central weapon in a legal strategy designed not to disprove what happened, but to make a jury uncertain enough about the witnesses describing it that a conviction would become impossible. In April 1911, Alterman gave her account to the grand jury. The pattern her testimony established, multiple workers confirming the locked Washington Place door, became the foundation on which the district attorney's office would build its case. The owners of the Triangle Waist Company were Isaac Harris and Max Blank, two Russian Jewish immigrants who had built the company into one of the largest shirtwaist manufacturers in New York City, employing as many as 500 workers at the peak of production. Both men had been on the premises when the fire broke out. Both had escaped via the roof of the Ash building, crossing to an adjacent building and descending safely. Their survival was not in question. Their culpability was. District Attorney Charles Whitman, who would later be elected governor of New York, announced charges against Harris and Blank in the weeks following the fire, manslaughter in the first degree and manslaughter in the second degree, based on the allegation that their practice of locking the Washington Place door during working hours had directly caused the deaths of workers who could not escape. The city received this news with something close to relief. The fire had produced an extraordinary public response, a funeral procession through the streets of Lower Manhattan that drew an estimated 120,000 mourners, a mass meeting at the Metropolitan Opera House where labor leaders and politicians demanded accountability. New York had the men. It had the physical evidence. It had a city full of witnesses and a population demanding justice. It seemed, in the spring of 1911, like a case that could not be lost. That assumption was the first mistake. The trial of Isaac Harris and Max Blank opened on December 4, 1911, in the Manhattan Court of General Sessions. The prosecution was led by Assistant District Attorney Charles Bostwick, an experienced trial lawyer who understood from the beginning that the case he was presenting was both stronger and more fragile than it appeared. The physical evidence was overwhelming. The locked door was documented. The death toll was established. The connection between the locked door and the deaths of workers who had tried and failed to open it was not seriously in dispute. What was in dispute, what the entire trial would turn on, was a specific and narrow requirement of New York State manslaughter law as it existed in 1911. To secure a conviction, the prosecution was required to prove not merely that the Washington Place door was locked on the afternoon of March 25th, but that Harris and Blank had known it was locked on that specific day. General knowledge that the door was sometimes locked was not sufficient. A pattern of locking was not sufficient. The law required demonstrated knowledge at the specific moment. Bostwick understood this going in. His opening statement, delivered on the morning of December 4th, laid out the prosecution's theory that Harris and Blank had personally ordered or condoned the practice of locking the Washington Place door during working hours as a routine measure to prevent workers from leaving early or stealing fabric scraps, and that on the afternoon of March 25th they either knew the door was locked or had given instructions that ensured it would be. The evidence for this was real. The legal standard required to transform that evidence into a conviction was narrow enough to drive a defense through. And the defense that Harris and Blank had retained was among the most capable in New York City. Max Steuer was 41 years old in December 1911, and already regarded as one of the finest trial lawyers in the country, a man whose courtroom skill was specifically suited to cases where the facts were against him. His strategy in the Triangle trial was not to challenge the physical evidence. He did not dispute that the door had been found locked, did not argue that the fire escape had held, did not contest the death toll or the circumstances of the fire itself. His strategy was narrower and more precise. He intended to destroy the credibility of the witnesses on whom the prosecution depended to establish his client's knowledge of the locked door. If the jury could not trust the witnesses, the prosecution could not meet its legal burden. The witnesses could not be trusted, Steuer would argue, because their testimony was not genuine recollection, it was rehearsed performance. The cross-examination of Kate Alterman was the moment the defense strategy became visible. Steuer asked Alterman to repeat her account. She did, in nearly identical language to her direct testimony. He asked her to repeat it again. She did. The words were the same. The phrasing was the same. The sequence was the same. Steuer pointed this out to the jury with quiet, methodical precision. He was not calling Alterman a liar. He was suggesting something more useful to his purpose, that her testimony had been so carefully prepared, so thoroughly rehearsed with prosecutors in the months since the grand jury hearing, that it no longer represented her independent memory of what she had witnessed. The jury, he implied, was not hearing what Kate Alterman remembered. It was hearing what Kate Alterman had been taught to say. The distinction was devastating. Alterman was telling the truth. Every account suggests she was telling the truth. But in a courtroom, the appearance of truth and the performance of truth are not the same thing, and Steuer had spent his career understanding exactly where that gap lived and how to open it wide enough to produce a reasonable doubt. Over 18 days, 155 witnesses testified. The prosecution called workers, survivors, and investigators. Their accounts were consistent on the central facts. The Washington Place door had been locked, workers had tried and failed to open it, and people had died as a direct result. The defense called its own witnesses, former employees of Triangle, who testified that during their time working for the company, they had never found the Washington Place door locked during working hours. Some testified that on the afternoon of March 25th, specifically, the door had been open. These accounts directly contradicted the physical evidence and the testimony of the prosecution's witnesses, but they introduced exactly what Steuer needed: a conflict of recollection that a jury could resolve only by deciding which set of human memories to trust. The physical evidence, the locked door, Beer's inspection report, argued powerfully for the prosecution. But physical evidence documents a state, it does not document knowledge. The defense witnesses argued that the door's locked state on the afternoon of March 25th was an anomaly, not a policy, something that had occurred without Harris or Blank's direction or awareness. Whether any of the defense witnesses were telling the truth, whether their memories were accurate or motivated, is something the historical record cannot fully resolve. What the trial record shows is that by the time both sides had rested, the jury had been given a genuine, if contested, factual dispute to resolve, and the legal standard required them to resolve any reasonable doubt in favor of the defendants. 146 people had died at a door that could not be opened. 12 men were being asked to decide whether they could be certain the owners had known it was locked. The gap between those two facts was where the verdict lived. On December 27, 1911, the jury in the case of the people of the state of New York versus Isaac Harris and Max Blank retired to deliberate. They returned in less than 2 hours, not guilty on all counts. Harris and Blank walked out of the courthouse free men. Outside, hundreds of protesters, many of them garment workers, some of them survivors of the fire, some of them family members of the dead, received the verdict with a fury that was also, for many of them, an absence of surprise. A juror interviewed in the days following the verdict explained the jury's reasoning in terms that were legally coherent and morally hollow. The prosecution had not proved to the required standard that the owners had known the Washington Place door was locked on the afternoon of the fire. The law had been applied as written. The law, as written, was not sufficient. The verdict did not say the fire was acceptable. It did not say the locked door was acceptable. It said that the legal mechanism available to the state in December 1911 was not capable of producing accountability for what had happened in March 1911. The jury had followed the law exactly. That, for the workers standing outside the courthouse in the December cold, was precisely the problem. The criminal acquittal was not the end of the legal reckoning. In the months that followed, the families of 23 victims filed wrongful death civil suits against Harris and Blank, seeking compensation through the civil courts where the burden of proof was lower and the question of knowledge less narrowly defined. The suits wound through the courts for 2 years. In 1913, Harris and Blank settled the civil claims. The amount they agreed to pay was $75 per deceased victim. The figure appeared in newspapers and produced a specific kind of public silence, the silence of people confronting a number so small it functions as an insult. The Triangle Waste Company had carried fire insurance on the building and its contents. The insurance payout the company received following the fire amounted to approximately $400 per victim, more than 5 times what the families of the dead received in the civil settlement. Harris and Blank had not merely survived the fire and survived the criminal trial. They had, by the actuarial logic of their insurance policy, turned a profit on the event that killed 146 of their workers. The civil settlement closed the last legal avenue available to the families. They had received $75 and a signature on a document that released the owners from further liability. Justice, in the formal legal sense, was finished. It was not finished for Harris and Blank themselves. In 1913, the same year they settled the civil suits, inspectors discovered that at their new factory, operating under a different name at a different address, Harris and Blank had again been locking workers inside during working hours. They were charged. They were convicted. They were fined $20. The fine was reported in the New York Times and several other city newspapers with a tone that can only be described as disbelief made typographical. $20. Not because the inspectors had failed, not because the evidence was thin, but because the penalty available under the law for locking workers inside a factory was $20. The legal system had had 2 years to observe what that practice could produce. It had watched 146 people die. It had conducted a 9-month criminal investigation and an 18-day murder trial. And the structural consequence of all of that, the price attached to the behavior that had made the fire fatal, was $20. The owners had learned nothing because the law had taught them nothing. The law had nothing to teach because the law had not yet been rewritten. That rewriting was already underway, but it was not happening in courtrooms. Frances Perkins was 31 years old in March 1911. She was working as an advocate for the New York Consumers League, a reform organization focused on labor conditions, and she was in the neighborhood of Washington Place on the afternoon of March 25th when the fire broke out. She witnessed the fire from the street. She watched people fall from the upper floors of the Ash building. What she saw that afternoon did not leave her. In the months that followed, she joined the staff of the New York State Factory Investigating Commission, a body created in the direct political aftermath of the fire, chaired by State Senator Robert Wagner and Assemblyman Alfred E. Smith, both of whom would go on to significant careers shaped in part by what the commission uncovered. Over the next 4 years, the commission's investigators visited 1,836 factories across New York State, documenting conditions, interviewing workers, and building an evidentiary record of systematic safety failures that extended far beyond the garment industry. The Commission's reports became the basis for 56 new pieces of labor legislation passed by the New York State Legislature between 1911 and 1914, covering fire safety requirements, mandatory sprinkler systems, limits on working hours for women and children, requirements for fire drills, and, directly addressing the mechanism that had made the Triangle fire fatal, the requirement that all factory exit doors open outward and remain unlocked during working hours. These laws did not restore anyone who had died. They did not retroactively punish Harris and Blank. They did what the criminal trial had failed to do. They changed the structure. They made the locked door itself illegal in a way that could not be argued around with testimony about what an owner did or did not know on a specific afternoon. The laws that emerged from the Commission's work became a legislative template that extended beyond New York. The specific safety requirements, sprinkler systems, fire drills, unlocked exits, limits on occupancy and working hours, were adopted in modified forms by other states in the years that followed and eventually influenced federal labor legislation through the 1930s, including provisions of the Fair Labor Standards Act of 1938. Frances Perkins moved from the Commission to positions of increasing influence in New York state government, serving as the state's industrial commissioner under Governor Franklin Roosevelt. When Roosevelt was elected president in 1932, he brought Perkins to Washington as his Secretary of Labor, the first woman appointed to a cabinet position in American history. She served for 12 years, longer than any other labor secretary. During that time, she was instrumental in the creation of the Social Security system, unemployment insurance, and the federal minimum wage. She always named the Triangle Fire as the event that had shaped her understanding of what government was for. In a 1964 oral history recorded the year before her death, she described watching the fire from the street and the recognition it produced in her. That the state had an obligation to intervene in the conditions of industrial labor, that market forces and individual employer goodwill were not sufficient protections for workers who had no power to negotiate their own safety. She did not call this a revelation, she called it obvious. The fire had simply made the obvious undeniable. The Ash building still stands. It was renamed the Brown Building and acquired by New York University, which uses it for classrooms and laboratories. In 1991, the building was designated a New York City landmark. In 2003, it was added to the National Register of Historic Places. Every year on March 25th, a commemoration is held at the building's Washington Place entrance, where a plaque marks the site of the fire. The names of all 146 victims are read aloud. The reading takes time. The names include Rosie Grasso, Bessie Gabrilovich, Celia Eisenberg, Daisy Lopez Fitzer, and 142 others, most of them women, most of them immigrants from Italy and Eastern Europe, most of them between the ages of 16 and 23. The youngest confirmed victim was 14 years old. Her name was Kate Leone. In 2011, on the 100th anniversary of the fire, the commemoration at the Brown Building drew several thousand people. Speakers included labor historians, union officials, and elected representatives. The names were read as they are read every year, not as a list but as a roll call, the way you call names when you are waiting for someone to answer. In 2012, a garment factory building called Rana Plaza collapsed in Savar, Bangladesh, killing 1,134 workers. Investigators found that factory managers had been warned the building was structurally unsafe and had ordered workers inside anyway. The exits had been inadequate. The workers had no meaningful ability to refuse. The garment industry that had operated in the Ash Building in 1911 had not disappeared. It had moved. The conditions it had created in Lower Manhattan, the locked doors, the blocked exits, the expendability of the people inside, had moved with it. Isaac Harris died in 1931. Max Planck died in 1954. The Triangle Waist Company dissolved quietly in the years after the fire. Neither man was ever imprisoned for what happened on March 25, 1911. Rose Schneiderman, a labor organizer who had known many of the Triangle workers personally and who spoke at the mass meeting held at the Metropolitan Opera House 8 days after the fire, said something that day that has been repeated many times since. She said that the working people of this country had been trying to organize themselves, and that every time they had tried, the rich had sent police and soldiers to destroy the effort, and that since the courts and the law and the government had failed them, all they had left was the organizations they built themselves. She was not wrong about the organizations. The International Ladies Garment Workers Union, which had organized a major strike of shirtwaist workers, including Triangle workers, in 1909 and 1910, grew substantially in the years after the fire, becoming one of the most significant labor unions in American history. The last survivor of the Triangle fire was Rose Friedman, who had worked on the 9th floor and escaped via the roof. She lived to be 107 years old, dying in February 2001. In her final years, she gave interviews in which she spoke about the fire with undiminished clarity. She was asked more than once whether she had forgiven Harris and Blank. Her answer did not vary. She had not. She called them murderers. She was asked whether she thought the legal system had failed. She said the question answered itself. On the wall of the Brown Building at the Washington Place entrance, the plaque reads simply, "This building, which stood as originally constructed, was the site of the Triangle Shirtwaist Factory fire. The door behind the plaque opens outward. It is required by law to remain unlocked during working hours. That law exists because 146 people died, proving that without it, the door would be locked. The plaque does not say that. The plaque does not need to. The door says it. Every day it opens, it says it.